So the Supreme Court recently granted review to the next big Second Amendment case, and it once again deals with state concealed carry restrictions and laws passed in direct defiance to their prior 6-3 ruling in New York State Rifle and Pistol Association versus Bruen. This is great news, so we need to talk about what is now happening in this case and how it is also impacting other concealed carry challenges that are pending in lower courts. Now, before we jump into this video, I want to say that if you guys want to support the channel, please consider subscribing to the channel. That, of course, helps it to grow. It also tells the algorithm that you appreciate this type of 2A content, and double check to make sure YouTube is not unsubscribed you, because they love to do that, especially on 2A channels. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're always expanding upon their benefits. In fact, they have new benefits coming out soon. So check them out using the links down below. And if you sign up using my code ARMEDSCHOLAR, you can get $50 off an individual sign-up plan or $25 off of a family plan. So as I mentioned in the intro, recently the Supreme Court granted review to another concealed carry restriction case called Woolford versus Lopez. This is huge for everyone in states like New York, New Jersey, California, Hawaii, and others, in all these states that currently put in place concealed carry bans after the Supreme Court issued their Bruen ruling. The Hawaii Woolford versus Lopez case sought emergency Supreme Court intervention, which surprisingly was granted review by the Supreme Court. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states and their catch-all public property bans are permissible under the Second Amendment. Recently, to the surprise of many, the Trump DOJ and AG Bondi actually stepped up in support of this challenge and pushed the Supreme Court to grant review to this 2A case. Well, that appears to have now paid off, and the Supreme Court granted review to this case, which again was surprising because it was an emergency review, it was interlocutory, and traditionally Supreme Court avoids all of these types of cases. And this grant by the Supreme Court is already impacting other concealed carry Bruen defiance cases which are pending in other jurisdictions. The California carry ban case and that challenge has already been stayed in light of the Supreme Court taking review of this case. However, there is another case in the state of New Jersey in currently the Third Circuit en banc panel. And in this case, the plaintiffs are asking for the en banc panel there in the Third Circuit to actually still move this case forward despite the Supreme Court taking review of the Woolford case. Now, if you're not aware, the Woolford case is a challenge to Hawaii's new laws on concealed carry passed in response to Bruen. This law, like others in states like New Jersey, tried to add more restrictions to concealed carry and create a default rule where individuals can carry firearms on private property only if the owner of that property provides express permission for you to do so. So plaintiffs, along with 2A organizations, sued the state of Hawaii to strike down those laws. Now, on review, a district court issued a TRO, which is a temporary restraining order, and that was later converted to a preliminary injunction. The court determined that there was no history or tradition to support this catch-all ban in Hawaii, and that's why this was then ruled on by the lower court. It eventually made its way to the Ninth Circuit. The Ninth Circuit 3-judge panel, along with reviewing a California concealed carry ban case, ruled against the plaintiffs here. They ruled in favor of Hawaii, finding that the catch-all property ban was permissible. Essentially there, they had a nuance where since Hawaii would allow the property owner to either give you express permission or post a sign, they found that that was different from what other states were doing like California. And so they allowed that law to move forward in Hawaii. En banc panel review was denied in the Ninth Circuit, and that has now led this case to the Supreme Court. And like I mentioned recently, the Supreme Court granted review to this case even though it was on an emergency basis, and even though it was dealing with an interlocutory issue. Now, it's likely that the Supreme Court broke their tradition of denying these type of emergency cases because there were some concessions made by the state of Hawaii at the Ninth Circuit level, and because also you have the United States government supporting the plaintiffs here, pushing the Supreme Court to grant review to this case. Now, in the recent amicus brief filed by the United States government, they stated that the near complete ban is flatly inconsistent with Bruen and the long history underlying it. Bruen recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. Now, one of the interesting things in that brief by the Trump administration was that they again pushed the Supreme Court to take this review on an emergency basis, not wait for a final merits. And essentially, they also pointed out that the state of Hawaii conceded at the Ninth Circuit level that nothing else needed to be developed at the lower court level. They said that this was a pure legal issue revolving around the Second Amendment, and no other evidence needed to be developed at the lower court level. And ultimately, the Supreme Court disagreed with the state of Hawaii and decided to grant review to this case. In the recent grant of the cert, we got a statement from the Supreme Court which stated that the petition is granted, limited to question 1 presented by the petition. So the question that the Supreme Court is going to review is whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. That means that the Supreme Court will directly address the catch-all property bans passed in defiance to Bruin in states like New Jersey, California, New York, Hawaii, and other states. It's also likely that the ruling here in this case will dig deeper into the prior Bruin holding and outline a little bit more and develop a little bit more, what needs to happen post-Bruin and give more guidance to these lower courts. Now, since the grant of review by the Supreme Court, a couple things have now developed. First, there have already been some motions filed to hold some of the other concealed carry cases and litigations until the Supreme Court rules on the Wolford case this term. So again, they're going to rule on this term. So some courts and some plaintiffs are asking to hold these cases. However, there is one challenge out of the state of New Jersey dealing with another concealed carry ban, which is asking for en banc panel review in the Third Circuit. And they're asking for the Third Circuit en banc panel to review this case and not hold it until, the Wolford case is decided. Instead, they argue that these cases and this issue is too important to delay for the Supreme Court to review the Wolford case, and they argue that the case should move forward at the Third Circuit en banc panel level. They state in that request that, as the panel recognized, this case poses a question of immense public importance. The Supreme Court has affirmed that the Second Amendment protects a general right to publicly carry arms for self-defense, which presumptively includes all places of public congregation. The question posed by this case is whether the exception will swallow the rule. If the Second Amendment is not truly a second-class right, then this case, which permits New Jersey to ban indirectly what they could not target directly, merits en banc panel treatment. Given the importance of this case and the fact that the panel unanimously upheld the district court's preliminary injunction of the private property default rule, a decision with which petitioners take no issue, this court should not delay en banc panel rehearing pending the Supreme Court's determination of that specific issue, and none of the other myriad raised by this case in Wolford versus Lopez. So in this New Jersey carry ban challenge, they argue that the court should not delay en banc panel review in this case because of what's happening now at the Supreme Court level with the Wolford case. However, I would put the odds potentially high that they would still hold this case. I think the Third Circuit en banc panel, could take the easy way out and say, hey, we're going to hold this case because the Supreme Court is reviewing a catch-all property ban. Maybe that's not directly at issue here with the New Jersey case. Maybe that's being conceded. If the Third Circuit en banc panel kind of wanted to take the easy way out, they could simply say, hey, we're going to hold this case until the Supreme Court rules on a similar carry ban issue. Now, the second thing that I've seen develop also is we're already hearing rumblings that some states would try to modify their laws, including potentially Hawaii. They may try to moot these challenges at the Supreme Court level, might try to moot the review there by the Supreme Court by changing the statute and changing some of the statutory language. This is a strategy that we've seen play out multiple times. We've seen the state of New York actually do that as well multiple times after the Supreme Court granted review to two-way cases. So that is something that we're hearing about. We have not seen that directly play out yet, but we're hearing rumblings that potentially that could be the play for some of these anti-gun states if they want to avoid this Supreme Court review and the impact of this case. So we will be keeping our eyes on these states to see, if they attempt to skirt the impact of the Supreme Court case by trying to remove or modify some of these vampire rules, these catch-all property bans. So as we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to like, comment, and subscribe. All of that helps, to tell the algorithm that you appreciate this type of two-way content and that it should share it to more people. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.